NASA once tried to force me to apply for disability retirement, and they said if we had to go that route, that they'd have to dismiss my EEOC claim because it would mean I'm no longer a qualified individual under the ADA. At the time, I knew it was a trick, but after researching this video, I know it's a very common trick. Some employers believe that if they can get us to say that we're not able to do our job on something like an application for disability benefits, that they can use that to justify firing us, dismissing our EEOC claims, or winning on summary judgment if our claim ever gets to a judge. Fortunately for us, that trick doesn't always work. Today's video is a request from one of you. The request was specific to SSI disability and how it might impact an ADA claim. But what I learned this week can apply to other disability benefits plans, not just SSI. Today I want to talk about a Supreme Court case, Cleveland versus Policy Management Systems. It's been used by employees in both the private and federal sectors to defeat an employer's motion for summary judgment in situations where an employee has to apply for disability benefits and fight an ADA claim in parallel. Today I'm just going to hit the broad strokes from a layman's perspective, but I'm going to leave some links in the description so you can check out what a lot of lawyers have to say on the subject. This is a fairly tricky situation with some heavy consequences. Cleveland had a stroke that affected her memory, concentration, and language to a point where she could no longer do her job. She applied for disability benefits through the Social Security Administration, saying that she was no longer able to work. SSA ended up denying her application, which is very common the first time. But around the time her SSA claim was denied, she had recovered enough from her stroke to be able to return to work with reasonable accommodation. Her employer claimed that because she had applied for SSI disability, she was no longer able to do the essential functions of her job with or without accommodation, like the ADA requires. So they turned down her request for reasonable accommodation and fired her for her condition. Cleveland filed a claim under the ADA and reapplied for SSI disability. SSI eventually declared that she was disabled and awarded her benefits. Her employer filed a motion for summary judgment on her ADA claim, saying that since SSI had found her to be totally disabled, she was no longer a qualified individual under the ADA. The lower courts actually granted her employer's motion, but Cleveland kept fighting all the way to the Supreme Court, who eventually ended up on her side. The Supreme Court acknowledged that there was an apparent contradiction between telling SSI that you're unable to work and claiming to be a qualified individual under the ADA. Being declared totally disabled for purposes of SSI disability does seem to contradict the idea that you're capable of doing your job with or without reasonable accommodations. It seemed to nullify an essential element of any ADA claim. First, you have to be covered by the ADA. The court also acknowledged that employers might try to pressure employees to apply for disability benefits as a means of dismissing valid ADA claims. The court did note that in some situations, an employee's claim for disability benefits might actually contradict their claim that they're a qualified individual under the ADA. But they also noted that there are a lot of cases like Cleveland's. To understand the difference, it's helpful to understand what disabled means to SSA, or whatever disability plan you have, and what totally disabled might mean in the context of the ADA. For instance, SSI presumes that some medical conditions are totally disabling. They have a list of totally disabling conditions and a set of criteria that determines whether you have one of those conditions. If you do, then you're presumed to be totally disabled. But SSA itself recognizes that having a total disability, by their definition, doesn't always mean total in actual practice. They recognize that there are individuals who could continue working under the right circumstances. The court determined that applying for or getting disability benefits doesn't necessarily exclude us from being able to bring claims under the ADA. So the court found that while employees can't ignore the apparent contradiction, we can rebut an employer's motion for summary judgment by explaining our circumstances in a way that would convince a reasonable juror that our statements were made in good faith and that there's no real contradiction. Now, SSA and some other disability benefits plans don't consider individual circumstances when you apply for disability. So you'll want to know how your specific plan works and go from there. Next, let's talk about the ADA. Like we said before, for the ADA to even apply, you have to be a qualified individual, which means you meet all the qualification requirements for your position and you're able to do all the essential functions of your position with or without reasonable accommodation. A lot of people find the with or without language confusing, but all it really means is that you have to be able to do the essential functions of your job either on your own without accommodation or with accommodation. Either of those two things is acceptable. If you tell EEOC that you have a total disability, they're probably going to take that to mean that you can't do the essential functions of your job even with reasonable accommodation. And in that case, the ADA doesn't cover you and you don't have a valid claim. And that's the logic that Cleveland's employer used in their motion for summary judgment. Cleveland successfully pushed back against her employer's motion for summary judgment by explaining that her statements to SSA that she wasn't able to work were made in a forum that doesn't consider the effect that reasonable accommodations might have had on her ability to continue working. While the ADA, in its definition of qualified individual, does take reasonable accommodation into account. Therefore, she said any apparent contradiction in the statements she made to SSI and the EEOC was due to a difference in the intent, rules, and terminology of those forums, not an actual contradiction in the facts of her case. Situations like this that involve disability benefits and the ADA in parallel can get convoluted and messy really fast. You have to understand exactly what you're saying, why you're saying it, and who you're saying it to. Of course, the best way around a convoluted situation like this is to avoid it in the first place. When you're filing an application for disability benefits in parallel with requesting reasonable accommodation from your employer, it's a good practice to state on your application for disability benefits that you are still capable of doing your previous job with or without reasonable accommodation. And when you're requesting reasonable accommodation from your employer, you might actually want to say that while you've applied for disability benefits, you are still capable of doing the essential functions of your position with or without reasonable accommodation. Sometimes the language is so tricky that I think it's meant to trip us up. The one thing you never want to put in writing is that you can't perform the essential functions of your job with or without reasonable accommodation. Because what that means is that even if your employer were to accommodate you, you still couldn't do the essential functions of the job. So again, if you're in this situation, dig into the references that I've left in the description so you're really clear on what with or without reasonable accommodation means. Some employers will do anything to try to defend themselves against a claim of discrimination, including twisting your statements and using them against you. So if you're applying for disability benefits and requesting reasonable accommodation in parallel, you can expect your employer to try to use that too. It is possible to get disability benefits and still prevail in your EEOC claim. Cleveland did it. But you have to really understand what you're doing and know exactly what you're saying in both forums. If you can do that, you can prevail. Fight smart, winning in to win.